5, 4, 3, 2, 1.
Welcome to the first live stream session by the Tennessee Supreme Court of Oral Arguments. We also want to say a special welcome to those of you who are watching on our YouTube channel. We began live streaming this way. It allows those folks who want to understand a little more about our system to see that firsthand.
Is there anything in the record here showing that your clients are not enjoying 6 clients a day and that's all they need to operate their business?
It's worked very well, and I'm sure it'll work well this time. And thank you for participating.
So there doesn't appear to be a case in the country that has held that the DDLA applies in this situation.
And didn't he wreck because he failed to negotiate a curve?
Yes, Your Honor.
So those aren't possibilities. Those are things that are definitely shown by the evidence.
In this docket, we will hear the 1,000th case live streaming for all 3 appellate courts here in the state of Tennessee since we started that process, thanks to the pandemic.
Have the assistance of the Administrative Office of the Courts and Mr. Jim Hivner and his staff.
To say we weren't quite ready for that would have been an understatement. But they did a marvelous job and worked us through it and got it set up so that we could continue to keep the courts open.
This could become a way for DAs to process cases for the Attorney General or whoever represents at the next step to say, oh, we made a mistake. It isn't dispositive, but it does not guarantee that the person can go back and withdraw their guilty plea and start from scratch.
We are so pleased to be in person for the first time in more than 2 years. And we want to welcome everyone who's watching us by live stream on YouTube.
If a defendant's sentence, if he feels that his sentence is illegal in some way, that can be contested under Rule 36.1.
Are you arguing that the trial judge also mediated the agreement?
If they're not talking about attorney's fees there, what would they be talking about?
25-year public defender. He was very calculated on what he was trying to do in this case.
I don't see a lot of limitations on what can be distributed.
Did the communication that Mr. Smythe sent on August 25th reference any extension or proposed extension of the due diligence period?
I think you're absolutely right about that. If he clearly says, we're done, I'm not saying anything else. But it seems to me what I'm seeing in your briefs anyway is you kind of went back and forth and maybe yes, maybe no, and then just kind of volunteered some things without even being questioned.
For remedy, that we just strike it completely, or do we remand it to the arbiter to make the concise breakdown?
So, but he didn't, the arbitrator
So there's really no mystery about where the numbers come from.
Now you're saying that they have a duty to make the recording to start with. That's not a Ferguson issue as I see it.
In just a moment, I'm going to ask you to introduce yourself. You need to tell us your name, and then you can tell us whatever it is you want to tell us about this case.
Yes,
okay?
sir.
We're going to give you 15 minutes to do that.
Would your position be the same if a party was dropped via amended complaint or via Rule 21?
Did you point that out to the court that the court had changed its mind?
After they pulled off kind of where the truck had been parked was at least 1, if not 2 air conditioning units that looked like they'd been dismantled.
This, according to the state's brief, still taking the position that her brother was this great guy who was just trying to help people and not do anything wrong?
I think it's close to the notary portion of the petition, but that's just blank. Is that what you're saying?
But this is the first I've ever heard of this argument since I've been on the bench that the judge needs to be taken into consideration in finding out an ability to pay that day.
If you were writing this opinion, how would you write out, this is what we mean by extensive criminal record?
We're not here picking sides, we're just trying to get to the facts.
What facts in the record was that finding based upon?
Were there any witnesses sworn in and testimony taken?
Or is it simply, it's in essence abuse of discretion because it was an error of law?
Those of you who have helped facilitate the court in accomplishing it this week, I appreciate your efforts, and I think that everyone has done a very good job.
We will stand in recess to the call of the next docket. Thank you.
This Honorable Court of Tennessee
Now adjourned.